Okay, guys, let's talk a little bit about plea bargains and how in the state of Texas, criminal defense attorneys and prosecutors come up with plea bargains. So in the state of Texas, there's something called deferred adjudication, there's something called probation, and there's something called prison. Those are the three main ways that criminal cases, when you're involved in a plea bargain, meaning the case isn't going to get dismissed, it's not going to go to trial. When you're involved in a plea bargain, those are the three main outcomes that your criminal defense attorney is bargaining around. And so, obviously, prison time, that's bad. Probation is a conviction on your record, and deferred adjudication is a special kind of probation where if you do everything you say you're going to do, the case is dismissed. Now, the way that it works is that the state of Texas controls your applications for probation and deferred adjudication. There are some cases where probation is automatic, some cases where deferred adjudication can be automatic, but in most felony cases, the state is controlling your application for deferred adjudication or probation. And they control that application by doing three things. They can either recommend the application, meaning that they're asking for it, and because your defense attorney has bargained for it, everybody agrees that an appropriate resolution for this felony criminal case is an application for or the judge to put you on deferred adjudication or probation. That's a recommendation. Then the state can also be silent. When they're silent, they're not arguing for or against, they're letting your attorney do the work of convincing the judge why you should be put on probation or deferred adjudication, and then the judge uses the evidence that the state presents, the evidence that they see in the stipulations, and they make their decision, either send you to prison or put you on probation or deferred adjudication. That's a silent offer. Then there are opposed offers, meaning you can apply for probation and then the state will argue against that application. Your defense attorney can put on evidence in favor of that application, and then the judge decides whether or not to send you to prison or put you on probation or deferred adjudication. That is an opposed offer. Now, there are other offers where the state is asking for time. Those are called to-do offers, okay? And sometimes those to-do offers are capped. Sometimes those to-do offers are capped and come with your ability to apply for probation or deferred adjudication. So you can apply for probation or deferred adjudication, but the judge can still, or the state will still cap the offer. Meaning you get let's give an example, 25 cap, a cap of 25 opposed. That means that you can apply for probation, you can apply for deferred adjudication, the state is going to argue against that application, and the judge can then decide to sentence you anywhere from the minimum to 25 years. And so all of those outcomes, either probation, deferred adjudication, or 25 years, right? All of those results will have meant that the judge has followed the plea bargain and you don't get a right to appeal. So it is really important when you're dealing with your defense attorney that you understand the language that your defense attorney is using. Many times I get calls from people who've accepted a plea bargain or who have been sentenced and they didn't understand exactly what they were plea bargaining to because their defense attorney was using lingo that they didn't get. So I hope this helps.